When an 18-year-old walks into federal court to testify under oath, and that 18-year-old happens to be the son of a former president, you're watching something that rarely happens in American history. And what happened in that courtroom this week tells you everything you need to know about how close prosecutors have gotten to the center of their investigation. I've watched legal cases unfold around powerful families for over 70 years. I've seen how prosecutors build cases, brick by brick, witness by witness. And I can tell you this with absolute certainty. They don't bring in a president's child unless they believe what he knows is worth the political firestorm that follows. That calculation alone tells you the evidence must be extraordinary. But here's what most people are missing in all the headlines and hot takes. This isn't really about Barron Trump. It's about what his testimony reveals, because federal prosecutors just introduced documents that directly contradict sworn statements from other witnesses. And when that happens, when new evidence proves people lied under oath, everything changes. I'm going to walk you through exactly what came out in that courtroom, why it matters legally, and what it tells us about where this investigation is heading. Because once you understand the pattern prosecutors are following, you'll see why this is moving much faster than anyone expected. Let me start with the basic facts, because they're stunning on their own. Last Tuesday morning, Barron Trump appeared in federal court in Manhattan. He was subpoenaed, meaning he didn't volunteer. He was legally required to show up and testify under oath about financial transactions involving the Trump Organization. The session lasted less than 2 hours. But in that time, prosecutors introduced 47 separate documents, email chains, text messages, financial records. And here's what makes this explosive. Those documents placed Barron in business meetings that other witnesses under oath claimed he never attended. Now, why does that matter? Because in federal investigations, when you can prove someone lied under oath about who was in a meeting, you can charge them with perjury. And once people face perjury charges, they start making deals. They start cooperating. They start telling prosecutors everything they know. That's the cascade prosecutors are trying to create. And Barron's testimony just triggered it. Let me show you the specific evidence that came out, because this is where it gets really interesting. The first document is an email chain from March 2023. In it, Barron is copied on messages discussing property valuations for Trump Tower. Not just copied passively, he's asked direct questions about square footage and comparable market rates. Now here's the problem. Executives already testified under oath that Barron was never involved in business valuations. They said he was just a kid, not part of operations, knew nothing about the finances. But these emails show him asking detailed questions about valuation methodologies, questions that demonstrate he understood how property values affect loan terms and insurance coverage. That's not a kid who knows nothing. That's someone actively participating in discussions that are at the center of fraud allegations. When prosecutors can prove someone lied about this, even if it seems like a small detail, it opens the door to question everything else that witness said. One proven lie makes every other statement suspect. In my experience, that's when witnesses start looking for immunity deals, because they realize prosecutors can now charge them with perjury, and the only way out is to cooperate fully. The second piece of evidence is even more damaging. Text messages between Barron and his father from June 2023. The messages discuss the accountants and making sure the numbers work. Now, think about what that language implies. Making sure the numbers work suggests awareness that the numbers might not work without intervention. That's called consciousness of wrongdoing. And consciousness of wrongdoing is the difference between an innocent mistake and intentional fraud. In any fraud investigation, prosecutors are trying to prove two things: that false statements were made and that the person knew they were false. These text messages speak directly to knowledge. They show awareness that financial numbers needed to be adjusted, managed, made to work. That's devastating evidence, but here's what should really get your attention. The third piece of evidence. An accountant from the Trump Organization was granted immunity 2 weeks ago. Under oath, with that immunity protecting him, this accountant testified that Barron attended meetings in late 2022 where executives discussed how to present financial information to banks and insurance companies. Let me explain why immunity is so significant, because this is crucial to understanding where this is going. When prosecutors grant immunity to a witness, they're making a deal. You tell us everything you know, and we won't charge you for crimes your testimony might reveal you committed. Prosecutors don't give immunity to people with clean hands. They give it to people who were involved in questionable conduct but are now willing to testify against others. That tells you three things. First, this accountant has first-hand knowledge of potential crimes. Second, those crimes are serious enough that the accountant needed protection from prosecution. Third, the information points to targets more important than the accountant. In every major white-collar prosecution, immunity deals follow a pattern. Prosecutors start at the bottom and work their way up. Lower-level employees get immunity first, then middle managers. The people at the top, the decision makers, they're the ultimate targets. If an accountant has immunity and is testifying about meetings Barron attended, prosecutors are building toward people above Barron in the organization. Now let me connect these three pieces of evidence because together they create a picture that's very difficult to explain away. The emails show Barron was involved in valuation discussions. The texts show awareness that financial numbers needed to be adjusted. The accountant's testimony confirms that this involvement happened in the context of meetings about how to present information to banks and insurance companies. When you put those three things together, you have a narrative, not speculation, not political bias, a documented sequence of events that prosecutors can present to a jury. And here's what that narrative suggests. People in the Trump organization were aware of problems with financial valuations, discussed how to present those valuations to get favorable treatment from banks and insurers, and then other witnesses lied under oath about who was involved in those discussions. That's fraud and perjury. Federal crimes, serious consequences. Now, the immediate question everyone's asking is, why Barron? Why bring in an 18-year-old who's been mostly out of the public eye? The answer is simple, because the documents prove he has relevant knowledge and because prosecutors believe that knowledge contradicts what others have said under oath. They're not targeting him. They're using him as a witness to build cases against others. But here's what's interesting from a strategic perspective. Barron wasn't given immunity. He was subpoenaed and required to testify truthfully under penalty of perjury. That tells you prosecutors don't believe Barron committed crimes worth prosecuting. They believe he has information, but they're not offering him protection because they don't think he needs it. That's significant. It means prosecutors think the criminal conduct happened above his level. He's a witness, not a target. The implications of this testimony are already spreading fast. Within 24 hours of Barron's court appearance, 3 congressional committees announced they're reviewing the new evidence, not because they're coordinating politically, but because federal prosecutors just revealed documents that touch on multiple ongoing investigations. When evidence surfaces in one proceeding, it becomes available for others. Congressional committees have their own subpoena power. They can demand documents and compel testimony. When federal prosecutors and congressional committees start moving in parallel, the pressure multiplies exponentially. But it's not just congressional committees. By Wednesday, reports emerged that at least 2 major banks are reviewing their relationships with Trump-related entities based on this new evidence. That's when you know this has moved beyond legal jeopardy into financial crisis territory. Banks don't care about politics. They care about risk. If the financial documents provided to them were inaccurate, and these court documents suggest they were, banks have legal obligations to report it. And once banks start reporting potential fraud, regulators get involved. The cascade accelerates. Credit lines get reviewed. Loan terms get renegotiated. The cost of borrowing increases. I've seen this pattern destroy companies. Once your banking relationships come under question, the financial pressure becomes almost impossible to manage. Now let me walk you through what happens next, because this is moving on a timeline most people don't understand. The pattern in major white-collar cases is predictable. First, prosecutors secure testimony from lower-level witnesses. Those witnesses provide documents and testimony that contradict what higher-ups have said. Then prosecutors use those contradictions to create pressure. They approach the people who lied and offer a choice, face perjury charges or cooperate, and tell us what really happened. Most people choose cooperation because perjury carries serious penalties, up to 5 years in federal prison. And once you're facing that kind of time, protecting others becomes much less appealing. That's the phase we're entering now. Barron's testimony has created contradictions. The immunized accountant has provided corroboration. Now prosecutors will start approaching the executives who testified that Barron wasn't involved and offer them that choice: cooperate or face charges. Some will lawyer up and fight, but my experience watching these cases suggests at least a few will decide cooperation is their best option. And once one person starts talking, others follow quickly. Nobody wants to be the last one holding the bag. The speed of this cascade tells you something important. Prosecutors have been planning this for a while. They didn't just stumble onto these documents. They've been building this case systematically, and Barron's testimony was a deliberate strategic move to create exactly this pressure. Now, I want to address something that I know is making people uncomfortable, because it should. Watching an 18-year-old testify in federal court about his family's business is unsettling. There's something that feels wrong about pulling the next generation into the legal consequences of the previous generation's decisions. That emotional response is valid. It's human. And regardless of your politics, it's natural to feel sympathy for someone that young being put in this position. But here's what I've learned in 7 decades of watching the justice system work. The law doesn't care about your last name. It cares about evidence. Barron wasn't subpoenaed because prosecutors want to punish him. He was subpoenaed because documents prove he has relevant knowledge about potential crimes. If those documents didn't exist, he wouldn't be there. If other witnesses hadn't lied about his involvement, his testimony wouldn't matter. The situation he's in now is a direct result of decisions other people made, both the business decisions that created legal exposure and the decision by other witnesses to lie about who was involved. That's important to understand because it addresses the fairness question. Is it fair that an 18-year-old is involved in this? Maybe not. But it's also not fair to let crimes go unprosecuted because charging them would be uncomfortable. The alternative, saying that some families are too prominent to investigate thoroughly, creates a worse problem. It creates a two-tier justice system where laws apply to regular people but not to the politically connected. And once you accept that kind of system, democracy itself starts to break down. Let me connect this to something broader because this matters beyond one family's legal troubles. Every democracy faces this test eventually. Can it hold its elite accountable? Can it apply laws equally regardless of wealth, fame, or political power? Most democracies fail this test. They create systems where the powerful play by different rules. And once that happens, public trust in institutions collapses. People stop believing the system is fair. They stop respecting laws they see applied selectively. And the social contract that holds society together begins to fray. That's why cases like this matter so much. Not because of who's involved today, but because of what precedent it sets for tomorrow. If prosecutors can follow evidence into powerful families, document crimes, and hold people accountable regardless of political consequences, it strengthens the system for everyone. If they can't, if political pressure stops investigations before they reach conclusions, then we've admitted we don't really have equal justice under law. We have a facade that crumbles when tested. Now, let me walk you through what this means for the multiple ongoing investigations, because Barron's testimony doesn't exist in isolation. There are at least 4 major legal proceedings where this evidence becomes relevant. First, the Manhattan District Attorney's investigation into business fraud. These documents showing Barron's involvement and the contradictory testimony from others go directly to that case. They provide new witnesses, new evidence, and new targets for prosecution. Second, the New York Attorney General's civil fraud case. That case is already alleging that the Trump organization inflated property values to get favorable loan terms. Barron's testimony and the associated documents provide additional evidence to support those allegations. Third, federal investigations into potential bank fraud. If property valuations submitted to banks were knowingly inflated, that's federal bank fraud. These documents speak directly to knowledge and intent, the 2 hardest things to prove in fraud cases. Fourth, congressional investigations into financial conflicts of interest. Multiple committees have been trying to understand Trump's financial relationships while he was in office. These documents provide new information about business operations during that period. Each of these proceedings can now incorporate Barron's testimony in the 47 documents introduced during his court appearance. That means what happened Tuesday doesn't just affect one case, it affects all of them. And in each case, the evidence creates pressure for additional cooperation. Witnesses who might have stayed silent when facing one investigation often crack when they're exposed in multiple proceedings simultaneously. There's also a financial dimension that's accelerating faster than the legal one. When major banks start reviewing their relationships with an organization, other financial institutions notice. Insurance companies reassess their risk exposure. Business partners start including protective clauses in contracts. The financial community operates on information and perception. And right now, the perception is that the Trump organization has serious legal exposure based on questionable financial practices. That perception becomes reality fast. Credit becomes more expensive. Insurance premiums increase. Business relationships that seem solid start to wobble. I've seen organizations destroyed not by legal judgments, but by the financial pressure that builds while legal cases are pending. The death spiral happens when legal exposure creates financial pressure, which creates more legal exposure, which creates more financial pressure. Breaking that spiral requires either resolving the legal issues quickly or having enough financial resources to weather years of pressure. Based on what's public about Trump organization finances, the second option doesn't look promising. Now let me address the political dimension because that's what many people are most focused on. Does Barron's testimony affect the 2024 election? Does it change Trump's political standing? The honest answer is, it depends on what comes next. If this leads to additional indictments, if more witnesses start cooperating, if the evidence of fraud becomes overwhelming, then yes, it will absolutely affect the election. Swing voters who determine elections care about basic honesty. Documentary evidence of fraud matters to them. But if the legal process drags on without clear resolution, if Trump can successfully claim persecution, if his base continues to see this as politically motivated, then the impact might be minimal on his core support. The problem for Trump is that this case isn't going away. The documents are real. The testimony is on record, and prosecutors are moving forward regardless of political pressure. That creates an ongoing story of legal troubles that will dominate news cycles through the election. And even if it doesn't change minds among committed supporters, it makes it harder to attract swing voters who want stability and competence. For other Republican candidates, this creates both opportunity and danger. They can position themselves as the electable alternative without Trump's legal baggage, but attacking Trump directly risks alienating his base. It's a calculation each candidate has to make. Do you go after Trump while he's vulnerable, or do you stay quiet and hope his legal troubles sink him without your help? Most will probably choose the latter, but that creates an opening for candidates willing to be more aggressive. For Democrats, this is straightforward. They can point to documented evidence, sworn testimony, and ongoing investigations without seeming partisan. The facts speak for themselves. The challenge for Democrats is not overplaying their hand. If they appear too gleeful about Trump's legal troubles, it can backfire and generate sympathy. Better to let the legal process speak for itself and focus on their own positive message. Let me bring this back to the fundamental question. What does equal justice under law actually mean? If it means anything, it means the law applies regardless of who you are. It means that if evidence shows you committed fraud, you face consequences. It means powerful families don't get special protection from accountability. That's a simple principle. But enforcing it when it involves a former president and his family is the ultimate test of whether that principle still holds. Throughout history, democracies have faced this test. Most fail. They create systems where elites are protected, where laws only apply to ordinary people, where justice becomes a tool of power rather than a check on it. When that happens, public faith in institutions collapses. And once that faith is gone, it's almost impossible to rebuild. That's what's really at stake here. Not one family's legal troubles, not one election, but whether our system of justice can function when it's tested by power and political pressure. The evidence presented at Barron's testimony will tell us a lot about where that test leads. If prosecutors can follow that evidence to its conclusions, indict people when the evidence supports it, and secure convictions based on facts rather than politics, then the system works. If they can't, if political pressure derails the investigation, if powerful people escape accountability despite clear evidence, if laws only apply when prosecution is politically convenient, then we've failed that test. And failing that test has consequences that echo for generations. So here's where we are. Barron Trump testified. Documents contradicted sworn statements from other witnesses. An accountant has immunity and is cooperating. Banks are reviewing relationships. Congressional committees are investigating. The machinery of justice is moving. The question is whether it can reach conclusions or whether power and politics will stop it before it does. I've lived through Watergate. I've watched Iran-Contra. I've seen the Clinton impeachment and multiple other scandals involving powerful people. This moment feels different. Not because the allegations are necessarily worse, but because the evidence is so well documented and the legal process is being watched so intensely by people with very different hopes for how it ends. What happens next will tell us something important about ourselves, about whether we still believe in equal justice, about whether our institutions can function when tested, about whether power still has limits in America. That's why I'm paying such close attention. Not because of partisan politics, but because the answer to those questions affects everyone, regardless of political affiliation. A system where laws apply equally is a system where everyone can plan, invest, build, and trust that the rules won't change based on who you know. A system where laws apply selectively is a system where trust erodes, where instability grows, where eventually everything becomes uncertain. We're finding out which system we have, and that answer matters more than any single election.